All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good afternoon and welcome to the Court of Appeals. Mr. Gene Sword just opened court for us, and we have one case for oral argument on this afternoon's docket. My name is John Tyson. To my right is Judge Toby Hampson. To my left is Judge April Wood. We are your panel for this afternoon's argument. We'd like to recognize and welcome several folks who are here in the audience today. We, just in the last 2 weeks, have resumed live oral arguments, and so we welcome you back to the court after a year's absence. Are there any preliminary matters to come before the court before we get started from either party? Okay, well then we call the case of Cohen versus Continental Motors et al., and we will hear from the appellant.
Thank you, Your Honors, and may it please the court. My name is Mike Miska. I'm here with our local counsel, Mr. Philip Miller, on behalf of the O'Neills and through the executor of their estates, Mr. Cohen. We're here on an appeal, pardon me. We're here on an appeal from the lower court, which dismissed this case on the grounds of personal jurisdiction. And based upon the briefing and the things that we submitted to the court, if we had this argument a few months ago, it may have looked a lot different and sounded a lot different. But since it was briefed in the lower court, and since we've come before Your Honors, the Supreme Court of the United States has come down with the Ford case. It's the Ford versus Bandemir. We did submit it as additional authority when it came out in March. Really, I'm going to focus this argument with the court's indulgence first on how that case applies to the facts here. I'm happy to discuss the other waiver argument towards the end of the discussion, again, with the court's indulgence, just because I think that these facts are very important. And really, it's because the Ford case has, according to the majority portion of that opinion, has resulted in some clarification and some change to the law as it relates to specific jurisdiction. Of course, the concurrences do draw some criticism as to whether or not it did result in a change in the law, but I think in the facts of the crash with the O'Neills, it makes it very clear that North Carolina is what they term a, quote, natural forum for this case. Backing up just for a moment, some of the basic facts. This case arises from a March 31st, 2013 aviation accident that took place here in North Carolina. Dennis and Deborah O'Neill were two North Carolina residents, and they owned that plane in North Carolina. The plane was serviced in North Carolina, and unfortunately, along the route of their flight, suffered a catastrophic engine failure. The reason for that was the oil inside the engine was able to exit the engine, and this is a piston aircraft engine, 6 cylinders, air-cooled, manufactured by one of the defendants here, Continental Motors. We'll talk about them in a minute. The oil in that engine was able to exit out of what's called a starter adapter. This component sits on the back of the engine on the accessory case, and it's used in multiple applications. This component was manufactured by Continental Motors, and it's specified for use in certain engine applications such as this one.
Is there anything in the record specific to this starter adapter as to how this particular starter adapter was introduced into, I'll say, the stream of commerce in North Carolina?
Certainly. And when you say this starter adapter, I think you mean the actual
I mean one. The actual one. I think the record does reflect that starter adapters generally had been introduced into the stream of commerce, if my recollection is correct.
That is absolutely correct, Your Honor. And this particular one was overhauled by Aircraft Accessories of Oklahoma. What happened was there was a problem with the plane. They thought the starter adapter was slipping, and they went to a former defendant, Air Care, for service.
And so would the Oklahoma company be sort of generally classified as the distributor? Or is that the,
They are what's called in aviation terms a repair station.
okay.
And that it has specific obligations and rights. It's not a distributor in the common sense, but they do take in components, whether it be something like a starter adapter or some other accessory, and they will overhaul them, certify that they meet the correct specifications, sign off on a specific form with the FAA, and put it back into service. Again, I think I might be getting lost in my own details here, but essentially, yes, they overhauled it, changed some components with new, sent it to the service center. The service center then said, okay, we're going to use this particular gasket. We're going to put it on the engine. They did that. They used, as the record, all throughout the record here, they used certain maintenance manuals. We'll get into that. And then signed off the aircraft as airworthy. Said this has been fixed in accordance with the applicable regulations and maintenance instructions, and we authorize that it's appropriate to be returned to service.
Mr. Miska, when Judge Gale entered his order, he noted that the installer, the mechanic who put the starter on the plane, had not been deposed or testified, and that it was unclear whether or not he had consulted with an online manual.
Yes, Your Honor.
Is there any clarification since that order on that one issue, or is that still the status today?
That still is the status, Your Honor. I will say that I take issue with the finding that it was unclear if he used it or not, because the logbook entry says, they use terminology, IAWMM, in accordance with the maintenance manual. It is a term of art, and as a repair station, again, we're going to use that term again, AirCare also holds a repair station certificate, and they're required to keep in their library and accessible to their mechanics the most up-to-date maintenance manuals, and we know that that happened here.
Is that material to the outcome of the case?
It is not, Your Honor. I believe that, and I advocate before this court, that those issues about the maintenance manual, all of that, are not dispositive of the outcome of this case, particularly given the findings at Ford. Those findings confirmed, well, actually what they do is they let this case be an easier one than Ford. Because in Ford, the record was actually depleted of any evidence that there was a specific act in either state trying to exercise jurisdiction over Ford as it related to those particular cars. They didn't say, okay, well, the defendant Ford, you gave this particular person a maintenance manual or a service instruction to follow when servicing these cars. We have that here. And while we can go back and forth on the nuances, I'll say, of that record evidence, it puts us actually one step closer to assuring ourselves that that jurisdiction is appropriately exercised here.
And I think that's sort of gets to the fundamental question of this case, which is how specific does specific jurisdiction have to be, right? And I think what we hear from your colleagues is that the relation to the action has to be pretty specific. Specifically, was there a use of this manual, not whether it was just introduced into North Carolina with the expectation it would be used. And the same with the starter. So I guess that's sort of my fundamental question: is how specific does specific personal jurisdiction have to be?
And this gets me back to the opening comment I had here. If we talked about this last February, we might be advocating that the standard for specificity has to be a lot higher than what it is after what the majority opinion has come down with in Ford. I highlighted a couple things from there. And on page 9 of the slip opinion here, Ford found that, quote, we have never framed the specific jurisdiction inquiry as always requiring proof of causation, i.e., proof that the plaintiff's claim came about because of the defendant's in-state conduct. So with that comment, I think it really shines light on what we're talking about. You don't have to have the exact specific link that they sent this instruction to AirCare who followed it for putting this defective component on the engine. Now, we have that here, but under the majority opinion in Ford, which is somewhat criticized by the two concurring opinions, they said that that causation is not required. Because when we step back and talk about what a company like Ford or Continental is, these are national and international manufacturers. They expect their products to be distributed throughout all states. And the lower court actually did make a finding that they marketed nationally. They had an employee here in North Carolina. Interestingly enough, the lower court disregarded the fact that Continental had registered to do business in the state of North Carolina at the time the complaint was filed and served. So they had every expectation that their products would be used, consumed, supported, all of those sort of things here in North Carolina. So why is it unfair then to not hail them into court? And I mentioned the concurrences, and there was the question, which was a very sort of pragmatic question, which is, if a company, in the case of Ford, has the activities that we know they do in Minnesota or in the case of Continental here in North Carolina, is it really a surprise for them to be hailed into the courts of that jurisdiction, especially in a case such as this one or the cases before the Supreme Court where the injury occurred within the forum, injuring plaintiffs who are residents of the forum? Here,
Mr. Gill, let me ask you one thing before you continue. On page 13 and 21 of the appellee's brief, they're citing the Goodyear case that originally went to the Supreme Court from this court, where this court was overturned on a search of jurisdiction against Goodyear. Are you familiar with that case?
I am, Your Honor.
Does Ford alter the Supreme Court's analysis from Goodyear?
I believe it clarifies the analysis from Goodyear. I believe that, again, if I were the dissenting justices in Ford, I would say that the opinion does alter the analysis for specific jurisdiction. And that's the criticism of it, although this is what we have now, which is lower courts are going to be grappling with the causation element. And I understand that's what we're talking about here. The reading of the majority opinion is that the causation element with a company that's a multinational seller, an injury to the plaintiffs in their natural forum, isn't one where the causation element has to have a direct line. They use that, the related to language. Initially, I think I cited Bank Brussels in our brief. You'll see it throughout the Ford opinion, which is a claim arising from or relating to the defendant's contact in the forum. And that's what we're talking about with Ford and with Continental here.
Let me ask you a question. The Ford case does say basically that a causal link is not required for specific jurisdiction, but they go to great lengths in that particular opinion to say that even though that isn't required, in the case of Ford, Ford marketed, sold, and serviced the same type of vehicles that led to the cause of action and was encouraging residents in the states of Minnesota and Montana to purchase those particular vehicles. How does that relate to your case?
Well, I think that's absolutely on point with what the record shows us here. We know that in the brief, limited period of time that Continental, that we got discovery on to talk about what does Continental do in North Carolina. We know that there was almost $4 million worth of business, thousands of transactions. There's 14 different fixed-base operators who signed up for and paid for access to their service literature. They had a distributor, Triad, here. They had an employee here. They registered with the state here. And by the way, the other interesting record fact that I don't believe was given sufficient weight is the fact that they even sent to AirCare 2 other starter adapters same component that we allege was defective and failed here. So we have all of this participation, and it puts Continental, which is one of essentially two general aviation engine manufacturers in the piston realm. There's either Continental or Cohen. They are they're a household name. And to say that they didn't expect to be here or expect that the products would be used, similar products used, that would be, I don't believe that would be correct. And I believe they did fully expect that these same products would be used in others. We talked, for instance, about Cirrus aircraft in some of the depositions in the record. And Cirrus aircraft also use a Continental engine, and there was a trip made by Continental out to North Carolina to help or to work with them on Cirrus aircraft. They use the same 550 series engine.
So but this all kind of goes to, again, that sort of fundamental question of, and I think what the critique of our courts was in the Goodyear case is the sort of blurring the line between general jurisdiction and specific jurisdiction. And so I guess for lack of a better question, what should we be looking to here? What are the elements you contend here constitute specific jurisdiction, minimum contacts for purposes of specific jurisdiction?
Well, and that is absolutely, and I understand the question, which is how do we keep general jurisdiction distinct and separate from specific, which is a difficult task in a different case other than this. This is where a part did make its way to North Carolina, but by every stretch of the imagination, this defendant expected its parts to be used within the forum. Does that create general jurisdiction? No, not necessarily. There is more. There is the support of the product here. There is the injury to the forum plaintiffs here. And there is, again, the expectation through business registration, employees, sales, distributor networks, all of those here make it so a company like Continental, just like Ford, had the expectation of doing business here, of its products being used here. So again, just as they said in Ford, why is it then a surprise that it should be litigating here when its products cause harm? If this were a case with plaintiffs outside the forum, again, not talking about forum shopping in the pejorative sense, but plaintiffs who somehow selected North Carolina or any other forum, and it was not a place of general jurisdiction for Continental like Delaware might be, then this court would have a much more difficult question before it. But because the connections are so strong, service, accident, residency, a registration of the aircraft, it doesn't create that same danger of blurring the lines between general and specific jurisdiction.
Moving to the issue of the manual and the subscription service, would you sort of kind of explore that issue a little bit and how that differentiates from just having the information out sort of publicly available on the internet?
Certainly, Your Honor, and that's really the line that distinguishes, there's two cases, Old Republic Insurance and Olympic Air, that were cited both in Continental's brief and I believe by the amicus curiae brief. And
the parties seem to have sort of a fundamental disagreement as to what the nature of that service was in those cases. I think your colleagues would argue that was more akin to a publicly available website.
In those cases, it was publicly available. But
I had it back.
Right.
I'm sorry.
Well, no. Your Honor, the Olympic Air and the Old Republic, they were publicly available passive websites. And the argument was that service literature was somehow available or disseminated in those courts, neither of them North Carolina, declined to find that just that nexus was enough. Now, of course, we're talking about two different cases outside this state in a pre-Ford world, but here we know that AirCare had to sign up and pay for access to the manuals. And that, again, that's elevating the conduct from just having a passive website to gaining income and revenue from AirCare and 13 other fixed base operators based here in North Carolina. Gave them the expectation, the understanding. They sent out emails. I think the lower court called them email blasts, but they did it to their subscribers. If you were just an operator of a Continental engine, you wouldn't necessarily get it. You had to be a fixed base operator who reached out and had the ongoing relationship with Continental.
So whether the mechanic actually viewed it or not is immaterial as long as the FBO is paying for the subscription price? Is that your argument?
I don't believe that it is immaterial if he viewed it, and in this case, the record from the designee was that he would have expected him to do so, and the logbook entry said what it did. But again, it is one of those.
Would he make the same entry if he had put this part on in the past and knew how to do it and had basically installed it based upon experience without consulting the online service?
That is a question, unfortunately, Your Honor, I don't have a clear answer to. Under the regulations, as I said, a repair station is required to keep current manuals, make them accessible. Whether or not this individual would have done so had he not done it, he does sign it and affirm it's a correct entry. So I can't imagine that he would.
According to the standards required, but those standards could be met by his own experience and personal knowledge. You will agree with that?
I will, Your Honor, I can't say that the regulations would necessarily allow him to do so, but he's not bound under Appendix D of Title 14 to follow, he's required to follow standards and practices. Whether or not he has to include those letters, I don't believe is required under the regulations.
But how does the fact that it's a paid subscription as opposed to just generally available information, why is that such a differentiating factor?
Again, it gives Continental the expectation and the knowledge that people here are using their products, that consumers, fixed base operators, maintainers, they're here. So that takes it out of the pure stream of commerce argument and moves it into, unfortunately, a little bit grayer of an area, but not one with just passive accessing of service literature. It's one where, yes, this is happening here, we know it's happening here, we're deriving a benefit from that business activity, this being from Continental's deriving a benefit, and certainly gives them notice that that's going to be occurring. I mentioned the word natural earlier, and the quote I wanted to mention is actually citing Bristol-Myers, and I think that case, while Goodyear is instructive, Bristol-Myers really brings us to where we are today. And Ford said, in sum, each of the plaintiffs brought suit in the most natural state based on affiliation between the forum and underlying controversy, principally an activity or occurrence that took place there. And it cited Bristol-Myers. And Bristol-Myers is instructive not because the non-resident claims were dismissed, but because the resident claims, where residents of California took Plavix and suffered injury in California, the court retained jurisdiction and allowed jurisdiction to be retained by California courts over those claimants. Those claimants are similarly situated to the O'Neills. They took the, in this case, they had the engine and the starter adapter, they used it within this forum, as opposed to being, again, an outside of forum plaintiff, consuming it within the forum. So, under all of those standards, Ford really sheds a lot of light and makes it clear that in a case such as this, where we have a record showing the larger context of Continental, again, some of which were argued to be disregarded by the lower court, but those larger contexts should not be disregarded even in a specific jurisdiction context. And that's because of the purposeful availment to the forum and the question of is the claim arising from or relating to. Now, I'm running shorter on time. I did want to mention the waiver argument that we included in the briefs.
I did want to stop you just one moment. I neglected to ask you if you did want to reserve time for rebuttal.
I did, Your Honor. I'd like to reserve 5 minutes.
Okay, I will give you, as we get closer to that, you have about a little over 2 minutes left if you want to preserve 5.
Certainly. I'm going to do my best.
Okay, thank you.
That's why I'm moving on here. So the waiver argument, the fact is this case has been around for some time. The accident happened back in 2013.
Would you concede there has to be more than the merely passage of time? to constitute waiver here?
Absolutely. Absolutely. I think that's made very clear by the case law, both federal and state, that passage of time alone is not enough. But in this case, we have active discovery. We have consent orders.
And would you, I mean, so in North Carolina, our personal jurisdiction jurisprudence seems to indicate you can decide personal jurisdiction at various stages along the case. It can be decided on the pleadings. It can be decided summary judgment on affidavits. It's probably even case law supporting having a mini trial on personal jurisdiction and minimum contacts. So how far, I mean, what constitutes a waiver? What actions constitute a waiver other than just ongoing litigation?
Well, it's not the ongoing litigation that is just the mere passage of time, as you suggested, Your Honor. What it is Continental serving discovery, noticing inspections, the consent discovery scheduling orders that were entered multiple times, and the expectation in 2017 of a 2019 trial date. So all of these things are conduct which is not just sitting back or doing nothing. This is something that is more than just mere passage of time.
Now,
And
they raised an objection to jurisdiction in their answer.
they raised an objection in the answer. That's correct, Your Honor.
And you're contending that their participation in the litigation and discovery is a waiver to that objection?
Yes, Your Honor. And it was more than just discovery. It's discovery, consent orders, appearances, those sort of things. And I think this also has to be viewed against the backdrop that all the while this was pending, Aircraft Accessories of Oklahoma raised an objection to personal jurisdiction, and we litigated that. They could have raised their own and chose not to. And the other thing is, any argument that there was some sort of ignorance or unknowing of what the nature of the plaintiff's claims were is belayed by the fact that Aircraft Accessories of Oklahoma, their connection is the starter adapter, a Continental part. We looked at it pre-litigation. It was immediately apparent what had been the cause of this accident, and that's why it was specifically enumerated in our complaint.
The federal agency that identified the crash also identified that, is that correct?
Your Honor, I hesitate to talk about the federal agency in the sense because the determinations, the probable cause determinations of the NTSB are not admissible, but they did identify the fact pattern that we allege in our complaint.
Okay. You have about 4 minutes.
Your Honor, I'll reserve the remainder of the time if that's all right.
Thank you, Mr. Miska. We'll hear from the appellee. Good afternoon.
Good afternoon. Thank you, Your Honor. May it please the court, my name is Lacey Smith, and I'm with the law firm of Armbrecht Jackson out of Mobile, Alabama, and along Elizabeth Scott with the Williams Mullen firm in Raleigh. I'm here today on behalf of Continental Motors. The due process analysis for specific jurisdiction requires 2 elements, purposeful availment and relatedness. Purposeful availment precludes a non-resident defendant from being sued in another state on the basis of forum contacts that were created by a plaintiff, a third party, or anything other than the defendant itself. If the purposeful conduct of the defendant creates sufficient minimum contacts, relatedness will then require that the plaintiff's claims arise out of or relate to the non-resident defendant's connection with the forum. Neither of these elements, standing alone, can satisfy due process. Rather, it's only the combination of purposeful availment and relatedness that assures the 3-way connection or nexus between the defendant, the forum, and the litigation that forms the essential foundation of specific jurisdiction.
Ms. Smith, I asked your friend about the citation to the Goodyear case on page 13 and 21 of your brief.
Yes, Your Honor.
And he has argued that the holding in that case is somewhat more limited or nuanced by Ford. I don't want to direct your argument, but I wanted to ask at some point if you feel like Ford has changed the burdens or the duties in this case.
Okay. I do believe that Ford Motor is a very narrow rule. However, it does expressly incorporate the 2 elements I just talked about, which are purposeful availment and relatedness. So the rule in Ford Motor is when a company like Ford, and that's a specific factual limitation of the rule, serves a foreign market for its product, and that's where you bring in purposeful availment. It's only if you have that connection, that first elementary connection created by the defendant's own conduct, that you move to relatedness, which is a separate inquiry. And that's where the location of the accident and any state interest comes into play. But in terms so to answer your Honor's question, I do believe Ford Motor still incorporates the traditional analysis, two-part analysis for specific jurisdiction. As to the evidentiary standard, because purposeful availment was conceded by Ford because of its extraordinary business activities inside the forum, that was not an issue that was addressed in Ford Motor. So to the extent that Ford Motor relaxes any evidentiary standard or does not require strict causation as to relatedness, which is the forum and the litigation connection, that cannot be applied to the primary consideration under a due process analysis, which is fairness to the defendant and purposeful availment.
Let me ask you a question. Does Continental Motors, in fact, market, sell, and service the same type of air parts that are at issue in this case in the state of North Carolina?
It does not. So again, that limitation of a company like Ford, Continental has nowhere near the extensive contacts, but in terms of, they did particularly focus in Ford on advertising, like you said. The only evidence in the appellate record regarding advertising is an affidavit from one of our, from a Continental representative saying that Continental didn't engage in specific marketing or advertising directly inside North Carolina. In terms of sales, we know that the products here were not introduced into this forum via a direct sale by Continental, or even when you turn to the starter adapter, that product was not sold into this forum by a Continental distributor. In fact, if I could elaborate a little bit on just the facts of this case, the O'Neills were the third owners of this aircraft that crashed in the forum.
This part had been replaced twice previously too, correct?
At least twice previously, yes, sir. And that's important because the original starter adapter that Continental put in this engine when it sold it to the airframe manufacturer, Lance Air in Oregon, that was removed by Lance Air in Oregon shortly after the sale. So that starter adapter that Continental put in the engine is gone. What we have here is a third generation starter adapter. It's actually a different, I admitted to say that when Lance Air removed the starter adapter, it replaced it with a different part model. So it's also a different part model. It is a Continental part number, but it's a different model of starter adapter used in a different application in this engine, and that decision was Cessna's. But the overhaul and, or the fact that this starter adapter was supplied by Aircraft Accessories as part of what's called a core exchange, that is an extensive overhaul that involves someone taking the starter adapter off of the engine, sending it to Aircraft Accessories in Oklahoma, and they completely disassemble it. And then they check the specifications and rebuild that with parts of their choosing. We don't have all the, some could be PMA parts, some could be Continental parts, we just don't know. So Aircraft Accessories, Continental's responsibility or involvement in the starter adapter as manufactured and assembled on the day of this accident is far removed from what it originally supplied with this.
So I mean, if causation if there was sufficient evidence to create a jury issue on causation as to whether there was some defect inherent in the starter adapter itself, or whether there was some negligent omission in the manual, creates a jury question, or whether the mechanic ignored the manual altogether as a sort of an intervening act. I mean, if causation is a jury issue, I mean, can personal jurisdiction, or at least the sort of special verdict factual questions, be a jury issue in this case?
Conceivably, I suppose they could be. I don't think we need to go there. I mean, product liability should attach to the product as supplied or sold by the person that's being held liable for it. So, you know, getting into, and I think that would complicate the analysis somewhat in terms of jurisdictional motions, but, you know, here, one of the reasons Continental was unable to have a good faith basis for filing a motion to dismiss from the outset is that the broad language of the complaint named various parts, and it wasn't until we got a discovery response saying, Continental, we think your liability in this case attaches from this overhauled starter adapter that was sent in from Oklahoma. That was what gave us the knowledge that we needed to file the motion.
And maybe that goes to the same question I asked your colleague for the plaintiffs, and that's how specific does specific jurisdiction need to be?
Well, it's definitely a very fact-specific inquiry. And then, but again, under Ford Motor, while we disagree with any sort of lightening of the standard for relatedness, when it comes to purposeful availment, Ford Motor actually affirms that a causation standard is appropriate there, because the last case to deal with the evidentiary requirements for purposeful availment was Walden. And since Ford Motor does not address that separate inquiry, we look to Walden, which says that the defendant's suit-related conduct must create substantial connection with the forum.
I have two questions raised on the appellate's argument. How do you respond to their argument that your company had filed or registered to do business in North Carolina? And two, are you claiming that you're exonerated when a parts rebuilder or remanufacturer takes your part? Does that absolve you of liability in that case?
As to the registration of Continental's, having a registration to do business in this forum, we don't think that's a relevant or weighty conduct in this case. That
Would it be
employee-
a factor?
I'm sorry, would it be a factor?
Would it be a factor?
I think all these factors are things you consider. I mean, we consider where the accident occurs, the state interest, even if we're looking at purposeful availment. So I do think you can look at all of the relevant, look at all of the defendant's contacts with the forum, but it's the weight and the relevancy of those contacts that's up to question, depending on whether we're talking about the forum to litigation connection on the relatedness side, or the defendant to forum on purposeful availment, because the law is so clear that only a defendant's own conduct can establish purposeful availment. But more direct to that, purposeful availment in this case starts with the factual nexus that the plaintiff offered for specific jurisdictions case, and that is only the service instructions and FBO services that was the internet platform that was used to supply it. So Continental having this one employee for a short amount of time in North Carolina and registering to do business there because of that, that person didn't have anything to do with FBO services. There's no evidence in the record that they had anything to do with this case. So I think we have to, for case-specific jurisdiction, we have to look at the specific basis that is offered. And I want to be clear that in this case, the only alleged nexus that plaintiff identified for the trial court was the presumed use of Continental's service instructions by AirCare through this internet platform called FBO Services during the installation of the overhauled starter adapter that came from outside the forum.
So recognizing that you will disagree with the entire premise of my question, and I accept that, you know, if the introduction of the service manual into North Carolina via the subscription service constituted sort of a purposeful availment, and there was an expectation that it would be used, and it's introduced in North Carolina specifically for the mechanic to use. The expectation is that it will be used. You know, even if it isn't in fact used, why does that not constitute sort of, I don't know, whatever the phrase is, purposeful availment or a minimum contact with North Carolina?
Yes, sir. So the pure foreseeability standard is a pure stream of commerce argument that I believe is not followed in North Carolina. I believe North Carolina, to the extent it even follows stream of commerce, does the stream of commerce plus test from Asahi. So that requires not just that Continental could foresee the possibility of some of its aviation components entering the form. That's an unfair standard, particularly in this context, because of the
Well, it's not even so much sort of foreseeing that could be introduced. It's the foreseeability of it was introduced into commerce in North Carolina with the expectation it would be in fact used in North Carolina. So even if ultimately, a jury finds that the mechanic didn't look at it and it was the mechanic's failure to do that constituted the intervening negligence here, why at a jurisdictional level, the introduction with the intent that it be used in North Carolina, why would that not constitute a contact with North Carolina?
Well, my reading of the cases is that the foreseeability component that we're looking at when we're talking about purposeful availment is what obligations does the non-resident defendant reasonably foresee as a result of this contact that we're talking about. So with FBO services, the initial sign-up process is a service provider reaching out and signing up for this profile on a website. It's a one-time annual payment, yearly annual payment of less than $500. And after that, there's no continuing obligation by Continental. It's an automated process whereby a service provider signs in as they see fit. They find what they want, and the automated the web program supplies that information. It's not requiring any affirmative action by Continental for it to function moving forward, and it's really within the control of the service provider. But before I move on from that, I do want to again say that I think the preliminary failure in this case that's very important is that the trial court found, based on the evidence in the record, that there's no conclusive proof that Air Care actually accessed FBO services and whether they accessed it for this particular installation that was of the allegedly defective starter adapter. So I think opposing counsel was asked a question about the reference to the maintenance manual in the Air Care invoice. And
Let me ask you a question about that. When someone is a subscriber and they're paying for access to this manual, do they get any other benefit other than just access to the manual? Or do they get any special certification, or are they allowed to put themselves out as an expert? And
Right.
What benefit do they have other than access to the manual, if any?
As FBO services existed at the time of this case, there is no evidence that there was any additional benefit. It was, you pay your fee, you have your access to Continental's library, and to use at your discretion. I think there was a related benefit of, you can come down to Continental's factory in Mobile, Alabama, and have a little weekend course on how to service engines or something like that. But it was, it was just this, that you signed up for this, and that's pretty much the end of it. But in terms of the manual itself here, the notation and the documentation, the only documentation in Air Care's file, shows that it says in accordance with maintenance manual as to the engine mounts. That's a completely separate component. And then we also have the entire Air Care file for this aircraft and engine in the appellate record. And there are service instructions from Cessna as the airframe manufacturer. There's no documentation of any Continental services instructions in the file.
So the airworthiness certificate standards comes from the federal, from the FAA, is that correct?
Yes, Your Honor.
So the manufacturer or rebuilder who's providing the parts, are they the ones obligated to meet the standard?
Yes, sir, and I'm glad you asked that, because you were asking earlier about the certification after Air Care aircraft accessories rebuilt and overhauled this component. So they sign what's called an 8130 form, and that's just a standard form from the FAA, and that makes aircraft accessories the certificating body for the starter adapter at that time. They're the ones that sign off under their repair station number saying, I certify that this part is airworthy and has been serviced and maintained in accordance with the applicable service instructions from the manufacturer. So
And that's that aircraft accessories was the one who did
they
that?
signed the 8130 for the starter adapter following their overhaul and core exchange.
I want to ask one quick question about the business that your client had under the name Continental Motors Aircraft Engines Incorporated from November of 2013 to August of 2015. That entity, did that entity market or sell or distribute parts in the state of North Carolina? What was the entity, what kind of business did it engage in?
Were you asking about you're asking about Continental Motors Aircraft Engines, Inc., that entity?
Yes.
Okay. There's no evidence that entity was marketing or engaging in sales calls or anything like that. That registration was a Continental employee who had been in Mobile and I believe was doing air safety investigations, moved to North Carolina for personal reasons. Continental didn't want to lose this employee and registered to have that person do business remotely, essentially. So that was not a sales agent. There's no evidence that this person was dropping in on local repair stations in North Carolina or making sales calls anywhere. There's no evidence of any of that.
Continental makes a variety of different types of engines, correct? Not just aircraft engines?
No, sir. They make general aviation engines, piston engines. Yes, sir.
Do they not make diesel engines as well for large trucks?
They do. Continental Motors does not make. I think Continental the corporate structure of Continental's changed from time to time, and there was the former defendant in this case, Teledyne. They might have had some involvement in making diesel engines for trucks, but during this time period, and according to the record, I don't believe there's any evidence of that.
I ask you that for a broader question. If a company, is our inquiry limited just to Continental's distribution of this specific part or just aircraft parts? Or can we looking at the Ford case, can we look at a broader presence? For example, if Continental manufactures other things, and there's a broader presence of those in North Carolina because there's a broader market for it. I think you agree this is a very limited specific part for a very limited specific product. Fair enough?
Yes, sir.
So is it fair if Continental is here on a broader presence, including registered to do business, can we consider the totality of their presence, or do we limit it to looking at this subsidiary or this, quote, line of business?
I think what Your Honor is driving at is the division between general jurisdiction and specific jurisdiction, which was addressed in the Goodyear case. And really, Daimler is where they draw that distinct line about these stream of commerce contacts and all these general business, what do you do inside this forum, unrelated to this litigation. Those contacts are not, they cannot be the basis of specific jurisdiction.
Well, for example, Goodyear has the largest tire plant in North Carolina. They don't manufacture their bus tires on buses in France. So can we impute their manufacturing operations on an unrelated product to a product that they never had any connection whatsoever with North Carolina?
No, sir, I don't believe they can, especially under Ford Motor, because I think one of the interesting things about that case is that the court really, the majority opinion hones in on we are dealing with a 1994 Crown Victoria and a 1996 Explorer. And they even, in the Minnesota case, I believe, when they did look at sales, they said Ford has sold more than 2,000 of this 1994 Ford Explorer, or excuse me, Crown Victoria. So when you look at our case, the trial court did find, and plaintiff's counsel just referenced the fact that approximately 2,900 component parts were sold by Continental, according to a sales spreadsheet that's also in the appellate court record. That's during a 3-year time period. So two things about that. First of all, when you go down the spreadsheet, if you look at that spreadsheet and you pull it up in the appellate record, it's going to say Triad Aviation almost down the whole thing. Looking at it to my best ability, I found 8 other customers outside of Triad Aviation. So the point being, that's a client-specific relationship. When you were looking at Ford Motor, And they talk about purposeful availment. The language they use is so clear about how you must pervasively and actively pursue, cultivate, serve the foreign market. And that's not just an individual person residing in the market. Walden tells us that. That's from Justice Thomas's opinion. That is, your contacts are so pervasive that you have a de facto presence in the foreign market, not just a client-specific relationship. So if we're looking at the sales in this case related to the components at issue, which again, plaintiffs' counsel has, or plaintiffs have previously just argued specifically on the service instructions. But if we do look at the products, we are dealing with very few sales of the starter adapter itself, and Ford Motor was specific that it's the product at issue.
But what you could see there's a sort of a factual difference between the number of starter motors for an aviation engine that would be sold in a single state versus the number of Ford vehicles that are sold in a state.
Well, and that's why the factual distinction there is so important. I think to the extent we're going to Ford Motor allows any loosening of a causation or a causal related standard for relatedness, it's for these, global companies like Ford who are, known to everybody that's walking down the street. You recognize their brand because they're advertising all the time. You hear there's billboards in the forum advertising for Ford Motor. They've got local dealerships, and I want to be clear, that's not what Triad Aviation was. Triad Aviation they sell aviation components. So 99% of Continental's sales in North Carolina during the time period are to this parts distributor, who then sells them to whoever they see fit. But we can't assume that all of those sales were going to North Carolina pilots or consumers. That there's no direct retail connection established in this case as to Continental Motors by Triad Aviation or any of the other conducts that are addressed in the order.
I asked you a little earlier if the intervention of a rebuilder would limit your liability or supersede, even if there was some inherent problem with what you manufactured. Would the fact that someone else rebuilt it from scratch, you might say, maybe use the core as you referred to it, does that also affect your liability?
We believe so, certainly, because again, products liability should attach to the product that Continental had its hands on and set. Even if we're looking at the stream of commerce, what Continental sold back in 2002, the starter after it put on that engine, and the engine as it left its facility in Alabama, was completely different, especially as this particular component, by the time it crashes in North Carolina.
Does the record reflect that this specific component had been used on another aircraft motor prior to being rebuilt and sent back for this aircraft?
The record does not reflect that to my recollection. Again, a core exchange is, I take my starter adapter off, send it into yours, and they have the various parts, and they pick them off the shelf and either put it back into the core you sent, or they start over with a completely new core and send it back.
No different than an engine rebuilder would take a Chevrolet or a Ford engine, and then they would completely rebuild that and use the core components and send it back. Is that what
I
you're
would say
looking
it's
at?
similar, but I do think that the FAA oversight and aviation engines such as this are so pervasively regulated by the FAA, and regulatory oversight is such that just having the fact, if somebody rebuilds a Ford motor, that I don't believe they have to sign a certification saying, I followed the manufacturer's instructions and this thing is safe to drive now. But in the aviation context, you do have to do that. So whoever's rebuilding it has to actively assert responsibility for that product.
Should you be charged with some greater liability or foreseeability because you're one of only 2 piston engine manufacturers for private aircraft? Does that impose a greater burden on you because you have, in effect, a semi-monopoly?
I do not believe so, because even then, there still has to be purposeful availment as to the product at issue.
Well, they don't have anywhere else to go. It's either you or Lycoming, right?
It is. But the question is, for purposeful availment, it's approached from fairness to the defendant. That's a primary consideration. So even if Continental and Lycoming split the market 50-50, what does that mean for a given state? This is a state,
Well, it limits consumer choice. You do agree with that?
I'm sorry?
It does limit a purchaser's choice.
It limits the consumer's choices, but they also, I mean, they have a choice to not fly as well.
So Continental Motors, though, used Triad Aviation in the state of North Carolina as a distributor, didn't they?
Triad was a distributor at the time of this accident, but none of the components here were sold through Triad. And again, that relationship is very targeted and specific, and it does not result in in Continental imprinting itself, or flooding the North Carolina market with 2,900 components in this case.
Even if the particular component in this incident wasn't sold by Triad Aviation, was this type of component sold by Triad Aviation?
Looking at the sales spreadsheet that I referenced earlier, I did a search, and I don't want to misstate it, so I believe, searching by the part number, there were six or eight starter adapters with this part number sold to Triad Aviation. So I think if you,
Over what period of time?
a 3-year period.
3-year period.
And I think it's important to, kind of do the ratio with the 2,900 sales that are in the order, and that was a factual finding of this court. I think 6 out of almost 3,000 is more of the isolated and sporadic contacts that the Supreme Court says cannot establish purposeful availment.
And is that 3,000 nationwide?
That was 3,000 in North Carolina, almost all to Triad Aviation.
Total parts, not just the starter motor, right?
Correct. So 2,900 component parts to Triad Aviation, approximately 6, less than 10 were the starter adapter at issue. None of them were involved in this accident.
So sort of an unfair question to lob at you with less than a minute left in the
I'll
argument.
give her a minute to sum up.
Okay.
You can go right ahead,
But
Judge.
there was a prior appeal to this court by your co-defendant in this case, and obviously it resulted in unpublished opinion, so no precedential value to that. But potentially, I guess, it could have some law of the case implications. So from your perspective, are there any sort of law of the case implications that would require us to look back at the aircraft accessories of Oklahoma case that would be in any way binding on us in this case?
I don't believe so, because Continental and aircraft accessories had played different roles in the facts of this case. In terms of the analysis that was applied there, I believe they looked at purposeful availment and applied the traditional sort of international shoe test. So I think that the court's prior decision as to aircraft accessories was likely correct, because again, they directly supplied the accident component in this forum.
Are
Continental
those
Motors-
parties adversarial?
I'm sorry,
Would those parties be adversarial? Could they be?
potentially.
I'll give you a moment to sum up.
Thank you. Okay. So, Continental Motors respectfully requests that this court affirm the lower court's decision. Specific jurisdiction fails in this case because there is no competent evidence in the record to establish the one and only nexus that plaintiff identified between Continental, North Carolina, and this lawsuit, which is the use of these instructions. Furthermore, the mere use of Continental's online service instructions inside this forum, to the extent that can even be assumed or established, doesn't purposeful availment, because FAA regulations required Continental to supply or to provide service instructions to the flying public. And the Old Republic case and Olympic Air that are cited in our brief find that those sort of contacts are geographically agnostic, because if you're having to send it everywhere, you necessarily aren't directing it specifically to any particular place. And then finally, as to waiver, the I-payment case that's cited in our brief says that the trial court's findings regarding Continental's minimal involvement in the infancy of this case and the lack of any bad faith in the timing of Continental's motion to dismiss are binding because they're well supported by the evidence. And with those facts, there's simply no basis to find that Continental waived its jurisdictional defenses in this case.
Thank you. Any other questions?
I do not.
Thank you very much, Ms. Smith. Rebuttal?
There is clearly a strong difference of opinion about the nature of the claims that are before this court and the basis for jurisdiction. The service instructions are not the sole basis of the claims against Continental. Whether this, and this goes to Judge Tyson, your inquiry earlier, counsel just stated that these components, if they're overhauled by a repair station, such as aircraft accessories, they have to follow the instructions. It enters and leaves aircraft accessories with the same defect, a plug that doesn't have a means of being secured. No safety wire, nothing to make sure that doesn't come out. Or, secondarily, or I guess parallel to that would be the instructions don't give sufficient warning and information about how to secure this critical component. So this case does not start and end or completely rest upon a service instruction. And I think that's very important, and nor should the inquiry of this court on the topic of personal jurisdiction. The starter adapter on this, the engine still enjoys its certification, is still a type certificated engine assembly from Continental Motors on this Lancer. And to your Honor's inquiry, there are only two major manufacturers of piston engines, but for this aircraft, you must use a Continental part. The case of Goodyear, I'm going to jump around with the court's indulgence. The case of Goodyear, the facts are that Goodyear USA conceded to jurisdiction here in North Carolina. But as your honors are clearly familiar, the Goodyear was not registered to do business in North Carolina. They had no place of business, employees, or bank accounts. They did not design, manufacture, or advertise their products in North Carolina. They did not solicit business in North Carolina themselves, sell or ship tires to North Carolina consumers. So those findings, that's on page 921, by the Supreme Court, very, very drastically contrast what is in the record before the court here today. Employees were here from Continental. They sold parts here, thousands of parts. They sold
You said employees. There was an employee.
There was an employee, I'm sorry. They were registered to do business here. And clearly that registration was in furtherance of their business of manufacturing and selling aviation engines and their component parts. Because part sale is an important part of any aviation manufacturer's business, just like it would be for a car manufacturer. So Goodyear and the facts before this court are very different. Yes, the families of the people who were deceased in Goodyear were North Carolina residents, but the injuries did not take place in North Carolina. They took place overseas, abroad. And they were from a tire that was not sold or manufactured, never distributed here in North Carolina. It was from Goodyear, Turkey. This is not the case that we have before your honors. This is a case where Continental engines are serviced here. There's Triad Aviation distributing their parts. There are, at the time, 14 other FBOs accessing their service information, receiving emails with updates about new service instructions, Air Care being one of them. Air Care using that information to service the O'Neill's plane. But as I said, this case is not solely resting upon whether there's a service instruction. It's also upon the use of a product that's here, because the design and the consumption and use of the product by the O'Neill's is very important. And while I only have a few seconds, I want to finish by saying...
I'll allow you a few minutes. We were generous with the other side. I'll certainly accord you the same privilege.
Thank you, Your Honor. While the personal jurisdiction argument, the use of Ford and consideration of Ford is very, very important. This causation, what Continental's advocating is the causation-only approach that Ford would like, to draw that hard and fast line that was rejected. Because there does not have to be this, the causation approach finds no support in the court's requirement of a connection between plaintiff's suit and defendant's activities. This is on page 8 of the opinion in Ford, citing Bristol-Myers. The same thing goes here. We don't need the hard line that we must access this specific instruction. We're looking at the totality of the presence of Continental here, vastly different than Goodyear, very akin to Ford. And finally, the last issue I'll touch upon is the policy implications as well. We had briefed this earlier, and that is, again, this is a natural form for the O'Neill family. This is where they're from. This is where the accident happened, where the product caused harm. It is sort of the textbook case for the exercise of jurisdiction over a non-resident defendant, and that is what the argument in part was as to Aircraft Accessories of Oklahoma, and this decision should be no different.
I'll give you a moment to sum up.
So finally, Your Honor, under the Ford case, there has been a change. There's been a clarification, and the presence of Continental is very akin to that of Ford. And we have the added element of a record showing the supply of service information and literature to Air Care that's related to the claims that's here. And that can assure this court that the jurisdictional, the exercise of personal jurisdiction is appropriate. Secondarily, and again, as I stated at the beginning, had Ford not come out, the order of my argument might be a little different, but the waiver argument is important with the participation in litigation. This has been years of delay, and especially in a case where it was known with Aircraft Accessories the nature of the claims, and Aircraft Accessories even did attempt to challenge personal jurisdiction, albeit unsuccessfully, but during those years of litigation, it was patently obvious what was going on, what the nature of the case was, and why we were all here. So for those reasons, Your Honor, we ask that the trial court be reversed and remanded.
Thank you.
Thank you, Your Honor.
Thank you, counsel. Any other questions? Any other questions? Thank you very much. Anything else before the court? Okay, if you will adjourn court. Thank you.
All rise.
Thank you for your good arguments.
This session of the North Carolina Court of Appeals is adjourned.